Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk, the most fact-driven, unbiased, true crime channel on the internet. First on the docket, what is Lori Vallow's attorney doing? Second, Scott Peterson getting another day in court. Will he get a new trial? Third, Jacob Blake takes a plea deal, then says he's innocent. Fourth, the McCloskeys are going on the offensive. Fifth, the Tennessee governor grants a reprieve, COVID or actual innocence. Six, a woman in a custody dispute charged with the death of her husband claims self-defense. The police say not so. And finally, our dumb criminal contestant of the day and our winner from last week. Let's talk about it. Good day, Crime Talk aficionados. This is Crime Talk, and my name is Scott Reisch. Thanks for watching. We know there are lots of channels out there that you could be watching. Thanks for taking the time to watch us. First, if you haven't done so, please hit that subscribe button. And as always, hit that little bell as well so that you receive notifications of when we go live or put up new content. We will go live tomorrow night, Tuesday at 6 p.m. Mountain Time on both Facebook as well as YouTube. We hope that you join us. And then immediately after that, we will have our Patreon live program for our Patreon members, where you will get the secret phone number and you can call and actually speak with us about anything that's on your mind regarding true crime or frankly just about any other matter, as well as you can put in for the Magic 8-Ball question of the week. Let's not forget about that. Let's get to our docket. First, what is Lori Vallow's attorney doing? Now, I have said before that I am not particularly impressed with Mr. Mark Means, Lori Vallow's attorney. And I'm not doing this just because I don't like the guy. I've never met the guy. He's primarily an attorney that does mostly civil work. When you go to his website, there was no mention of criminal work. It was all civil, family law, and mediation related. I have not been impressed with how he has conducted himself in court. I have not been impressed on the issues that he's brought before the court. Particularly, I was less than impressed with his issue regarding the bond reduction because he somehow thought that his telephone call or calls were recorded by the jail when he was speaking to Lori Vallow. That has nothing, in fact, to do with one of the considerations that the court has to consider in making a determination of whether bond should be reduced. And frankly, it was a complete waste of time, and I don't think it scored any points for him or his client before the court. The one thing that Mr. Means did was that he waived the preliminary hearing for Lori Vallow. That was probably the best decision that he has made thus far. And the reason for that was because the attorney for Chad Daybell, Mr. Pryor, did a very good job at the preliminary hearing. And I hope, since these two, Means and Pryor, share office space in an office share type situation, that Mr. Pryor told Mr. Means to keep your mouth shut, don't do a thing. Mr. Means, and we've talked about this, has gone on some weird Twitter rants about witnesses need to come forward and he needs more resources, that he can't do it all himself. Well, that's the time that an attorney probably needs to withdraw if he doesn't have the adequate resources in which to zealously and adequately represent his client. And the other week, we did a video about this as well, and I just had to go back and look based upon some of the comments that were made regarding that video that we made about the request by Mark Means in his multi-page letter to the district attorney in this particular case. It was dated October 19th, and it was a letter by Mr. Means on behalf of his client to the prosecutor, Mr. Robert Wood. Now, of course, Mark Means or his office or somebody associated with the case leaked the letter to the news media. I really don't see what good would come from leaking the letter. This is nothing more than a discovery request. Now, as I go through this discovery request and this multi-page letter, I just don't know why he is asking for certain things. We'll get to those in a second, but let me just explain generally. Sometimes defense attorneys make the mistake of thinking they need to get all of the information out there, and then having the prosecutor go get it, okay? The prosecutor only has an ethical obligation to get information that it was in or within their care, control, and custody. What does that usually mean? Obviously, if it's in their possession through the DA's office, they have a duty to turn it over. And we've talked about this under Brady v. Maryland. Any evidence that is exculpatory or any evidence that is inculpatory, any evidence that increases one's exposure to criminal liability has to be turned over. But oftentimes, defense attorneys get wrapped around the axle and they go looking for stuff. And what they really do is they actually go and help the government put their case together and say, hey, we're missing this piece of evidence. Go get it for me. And the DA suddenly says, wow, that's great. Thanks a lot. The best source of information in a case like this is going to come from your client, okay? And I'm telling you, as a defense attorney, you want to go and be able to get the information on your own. How do you normally do that? The defense has to hire an investigator. Yes, investigators can be expensive. Yes, it can be time consuming, but there's also ways for you to reduce those expenses by the attorney tailoring what needs to be asked and what needs to be investigated, not just let the investigator go on a carte blanche running around asking all kinds of questions. It can be tailored. But you want to be able to get that information yourself. Why? Because if it's bad, guess what? The defense doesn't have to turn it over. So the defense wants to be able to get their information that they need to help build their defense. And the best way of doing that is by hiring an investigator. It's an absolute necessity, particularly in a case like this. You have to be able to go talk to witnesses. You go out and you re-interview every witness that has made a statement in this particular case. You go ask the witnesses that haven't been interviewed. And obviously we don't have all the witness statements that have been made in this particular case of both Lori Vallow and Chad Daybell. But an investigator needs to go talk with them because there's always something that has been left out. I always tell my attorneys, I tell the investigators that work for us, assume nothing. I don't care if they wrote it in their report in their own handwriting. Go ask them again. There's always something someone will add to their report that may make a difference. And I've said this before, most criminal cases do not turn on the law, they turn on who can find the best evidence. That comes from investigation. That's why you need to do it. But you don't want to let the government know about it. You want to let them know about it at court. And let's say you only have to turn it over if you're going to use it in your case in chief. You can have a document where somebody has said something contradictory. You can hold it. You can hold on to it. Lie in wait until you have cross-examination and then say, isn't it so you said this, this, and this? You don't have to turn that information over that you learn as a defense attorney unless you're impeaching that particular witness and they deny it. You have to then turn the document, the report over. So you have to be smart about it. But you don't want the prosecution to know what you're doing. The other thing you try to avoid is subpoenas. When you subpoena a record as a defense attorney, you have to send a copy to the court. Sometimes in federal court, you have to get a approval from the court. And guess what? Then the other side knows what you do. And when the documents come in, they get both copies of it as well, which is fine sometimes if you're talking about phone records or something like that. But go do it yourself if you can. If your client has access to his own cell phone records, don't subpoena them. Get authority from them and you go get them yourself through your investigator. Have them log in. Have them obtain those records prior to asking for the prosecution. And everything that Mark Means asked for from the prosecutor are things that he should attempt to go and get on his own. And why would you want them to go get some of this information? If you think it's exculpatory, go get it yourself. For example, Mr. Means requests any and all audio or video recordings, communications, email, text, social media posts, voicemails, videos, statements, pictures, police reports, and any and all other agency reports, notes, charts, graphs, files, reports, compilations, and or the like in regards to the defendant Lori Vallow pertaining to any currently pending charges or contemplated charges regarding the minor children identified in this case. Guess what? No brainer. The prosecution already has to turn that information over. This is just a waste of time and effort on behalf of the defense. I get it. Sometimes I write lots of letters saying, please turn this information over, but it's actually of relevance. He wants all the reports, video recordings of Chad Daybell. Guess what? He's going to get that. It would already been turned over. Any and all audio or video recordings, communications, email, text messages, blah, 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 for Melanie Gibb, right? That's the friend of Lori Vallow, who basically was asked to lie and then didn't want to do that. So Mr. Means is requesting all of those emails, texts, reports, everything under the sun, currently pending charges contemplated against minor children. Guess what? Only if they are in the care, control, and custody of the district attorney or police agencies that report directly to them. They would have been turned over already, if they even exist. But the government cannot go and tell somebody, give me all your text messages, emails regarding everything. You have an expectation of privacy. You don't have to turn that information over. If they think there's some other information, there's some communications back and forth between Lori Vallow, Chad Daybell, and Melanie Gibb, the client should be able to go get them themselves through whatever source or means that they were actually being communicated to and from. Anyway, the letter goes on and on and on, and it's just a bunch of boilerplate language. Turn this over, and it reads more like a generic boilerplate general discovery request. And frankly, the definitions and everything sound more like it comes from a civil case for sure. The prosecutor has responded in this particular case saying, we've turned over some items. This is an ongoing case. We turn it over. We're complying with the rules of discovery. Their obligation is continuous and ongoing, and they'll comply. But they don't have to go out there and get certain things. Mark Means threatened to go to the judge and have a hearing regarding these discovery disputes if this was not turned over to his office no later than October 29th of 2020. And to date, I'm not aware of any filings by Mr. Means in any way seeking some sort of relief from the court. This is just another poorly planned media hoax on behalf of Mr. Means. This did not get him anywhere as it relates specifically to the defense of Lori Vallow. Some of this stuff is, I just don't get it. All autopsy, toxicology, DNA, fingerprints, and other like records, reports, evidence, photographs, videos, recording communications in regard to minor children cited above and or deceased Tammy Daybell, deceased Charles Vallow. Once again, does he really think he's going to get all that information? That's not in control of them, and those results will in fact be released, but there's an ongoing investigation. They don't necessarily have to turn those over. They want all the jailhouse audio and video recordings. Be careful what you wish for there, Mr. Means. My experience is nothing good comes from jail calls. Usually what comes from jail calls are admissions, all right? Admissions by defendants talking about the facts of their case, even though their attorneys have told them not to talk about it. When I get calls on a disc or being downloaded from the district attorney, it's usually because there's something bad in there. Why? They have to turn over everything, inculpatory and exculpatory. I've yet to hear any good exculpatory calls from the jail. And how is the defense going to introduce those anyway? You can't, right? Because that would be self-serving hearsay, which would not be admissible. You can't just play the calls. You have to have your client testify. I just do not get what Mr. Means is doing. Hopefully he will prove me wrong. And if he wins this trial, I will be the first one to say I was wrong. I, however, am concerned. I'm concerned about the record. I'm concerned that if there is in fact a conviction, that there will be post-conviction matters, and it will include issues related to the effective assistance of counsel. Not the duty of the defense or the court to raise those issues, because everyone is entitled to a lawyer of their choice. But I just don't think Mr. Means is up on his game for this particular case and is completely out of his league. Maybe I'm wrong. We'll wait and see. Next on the docket, Scott Peterson. You know, that guy that's been in custody for the last 16 years and his death sentence was recently vacated as a result of irregularities in the jury deliberation process. And not to mention, the California Supreme Court has also said go back and hold a hearing regarding irregularities relating to a juror in this particular case. Well, needless to say, the prosecution wants to go forward immediately on the resentencing in the penalty phase for Scott Peterson, and that will now take place on January 21st of 2020. Needless to say, the family of Laci Peterson was trying to move on. I mean, it has been 16 years, for goodness sakes, and now they have to go through a penalty phase for this trial and still may have to do a retrial all over again for the Scott Peterson case. I think it would be a much different result the second time around, just given the possibly lack of interest today versus the circus that took place back in 2004. We'll see if the prosecution can meet their burden. Penalty phase, like I said, will go forward on January 21st. Seems a little unusual that they wouldn't wait for the whole issue to be resolved regarding whether Scott Peterson should be entitled to a new trial. Everybody knows, regardless of what happens on that portion of the motions hearing that is yet to be set, that it will be appealed by either side. We'll keep you updated as things progress. Next on the docket, remember Jacob Blake? He was the young black man shot by a Wisconsin police officer in the back while he was reaching for a knife and disobeying the police commands to not reach for the knife in the car. He was being arrested on the date in question because he had an arrest warrant regarding sexual assault charges related to allegations from one of his previous girlfriends and I believe mother of his children. Well, Mr. Blake was given a PR bond and he was in the hospital the first time he appeared for his advisement on that case, and he has now reached a plea deal. He pled guilty over Zoom to 2 counts of disorderly conduct and domestic abuse and was sentenced to 2 years probation. In exchange for his plea of guilty to the disorderly conduct and domestic abuse charges, the 1 count, the felony count of criminal trespass, and the felony count of 1 count of third-degree sexual assault and domestic abuse was dismissed. Now, Mr. Blake pled guilty and then stated, quote, "Honestly, Your Honor, although I pled guilty to this, I don't consider myself to be guilty," end quote. We've talked about this before many times when it comes to the Watts case. When you plead guilty, you admit as a matter of law and as a matter of fact, that's what you did. Whether you like it or not, that is what happens when you plead guilty. That's why you shouldn't plead guilty to things you didn't do. I'm a little surprised that the court would even accept the guilty plea if Mr. Blake simply said, "I'm just pleading guilty to get this over with, but I really don't think I'm guilty at all." Then don't plead guilty. That's what jury trials are for. That's what making the government hold their burden of proof for a trial. So don't plead guilty if you're innocent. I've told many a client that over the year. If you did it, it's a great deal. If you didn't do it, it's a terrible deal because you're innocent. He probably was looking at the consequences of losing and going to prison, which is certainly something he should consider. But those are always things that one considers when pleading guilty. And the bottom line is, if you didn't do it, then don't plead guilty to it. It is also worth noting that the young woman involved in the case who made the original allegation is no longer cooperating with police, and that makes it very difficult for the prosecution to have to force her to come forward and testify. They could easily have done that, but given the circumstances regarding this case, regarding Mr. Blake, the fact that he's paralyzed, she doesn't want to cooperate, and he's willing to take a guilty plea. Mr. Blake got something that he wanted, the felony charges to go away. The prosecutor got what they wanted, a conviction. Because at the end of the year, what do? They like to keep track of all those little convictions so that they can go back to whomever gives them their money, their county commissioners, the state legislature, and say, look how busy we are. Look how many cases we've handled, why we need more money. It's always about the money, ladies and gentlemen. We wish Mr. Blake well. It is also worth noting that the officer that shot Mr. Blake has not been charged, nor do I think he will be, given the fact that they found a knife on the floorboard where Mr. Blake was reaching. Let's take a quick recess. Please go to CrimeTalkSearch.com and get a background subscription service today. You'll be absolutely happy that you did. I'm telling you, there's someone out there that you want to know more information about. Maybe it's just curiosity. Maybe it's someone that you're going to get involved with romantically. Maybe it's someone you're going to get involved with in a business relationship. You would kick yourself if you found out the information that could have been located in this background search. When you do this background search and you sign up, you can search as many people as you'd like completely anonymously. And that report that's going to be generated literally within minutes while you wait is going to search millions and millions of public records. And that report is going to be generated. And it's going to have criminal convictions. It's going to have bankruptcies. It's going to have judgments. It's going to have marital records, property records. It's also going to give you information that's going to show emails that are associated with this person. So if somebody has 20 Gmail accounts, you may want to get curious. Is that because that's where all the Tinder accounts go to? If they have social media accounts, why do they have multiple ones? Why aren't they telling you about those? As well as phone numbers. Same thing. Why does somebody need 3 burner phones? Maybe they're up to something not good. Only way you're going to find that out is if you go and get a background subscription service. Please go to CrimeTalkSearch.com. You'll be happy you did. Next on the docket, the McCloskeys. That's right. You all have seen the photograph of the McCloskeys standing outside of their Missouri home with firearms when people were going past their residence. And yes, those protesters did break down a gate. They were trespassing, according to the McCloskeys. Needless to say, the McCloskeys have been indicted. Not exactly sure why they were in fact indicted, but you can get an indictment for just about anything. Needless to say, those charges will be resolved in a court of law. The story for today is that the McCloskeys aren't taking it anymore. They're going on the offensive. That's right. The McCloskeys are suing the photographer in court that Bill Greenblatt, who works for United Press International, was trespassing when he took the photograph. They're also going after Redbubble, an online marketplace for merchandising, basically using their likeness in all of their merchandising. And they want all the royalties that are coming in, basically saying that they are violating their rights. The McCloskeys are saying that their images is being exploited and they should be entitled to receive money from anything that UPI or Redbubble receives by way of royalties. Ironically, United Press International is also thinking about countersuing the McCloskeys because UPI doesn't want the McCloskeys using the image themselves. Apparently, they were going to put it on their greeting cards this year, and now UPI says, no, you can't do that. So I guess the courts will have to sort out who owns it and whether, in fact, the people were, in fact, trespassing and had no right to take the photo. But I think that the photo was taken in the public. You have no expectation of privacy when you go into the public, and that photo belongs to the photographer under copyright laws. Who knows? Maybe the court will say otherwise, but I don't think this case is going very far. Next on the docket, the Tennessee governor grants a temporary reprieve to a death row inmate over COVID-19 concerns. Well, could it also be actual innocence? We'll have to wait and see. Tennessee Governor Bill Lee has granted a death row inmate a temporary reprieve from execution due to the challenges and disruptions caused by the COVID-19 pandemic. That's according to the governor's office. That's right. They're concerned about witnesses coming to Purvis Payne's execution, which was currently scheduled for December 3rd. So now they've moved it back to April 9th of 2021, hoping that the COVID matter will be hopefully a thing of the past. Now, Mr. Payne has 2 death sentences after he was convicted in 1998 of the first-degree murder and stabbing death of his then-girlfriend and her 2-year-old daughter. Mr. Payne was also convicted of assault with intent to commit first-degree murder of his girlfriend's 3-year-old son who actually survived. Now, the case does get a little more interesting because back in September, a judge ruled that evidence in this case can be tested for the first time for DNA. Now, obviously, that is significant. And if DNA was not done at the time of the murders, what is wrong with getting it done? Now, that should be rather quick. It should take no more than a couple of months at the most to get the evidence, to make sure everybody can be there, to watch the procedures, do the testing, and do the interpretation of the results. So hopefully, if there is no DNA evidence that is exculpatory, this matter will go forward. Why? Because criminal cases have to have finality. There has to be an end. Now, nobody wants someone to be put to death if they are innocent more than this individual, me. That's right. But if there's no exculpatory evidence, it would seem as though Mr. Purvis has had his day in court and the matter needs to go forward. Next on the docket, a woman embroiled in a bitter custody dispute with her husband, who just happened to wind up dead, claims that she was being attacked by her husband. The police say, yeah, not so much. The interesting thing is that this woman is a former professional ballet dancer, and Ashley Benefield, she's 28. She has been accused of fatally shooting her estranged husband in Florida, and she was charged on November 5th of second-degree murder, like I said, for the death of her estranged husband, Doug Benefield, who was 59 years of age. Purported by the arrest affidavit that Doug Benefield had gone to the home where Ashley Benefield was staying at the time, and they were the only people inside the home when shots were fired. Doug Benefield was rushed to a hospital via ambulance, but was pronounced dead upon arrival. Ms. Benefield allegedly told police that she was attacked by her ex-husband, but detectives found no evidence to indicate she was acting in self-defense. The police stated that they were looking for any type of injuries, torn clothing, any sign of a struggle whatsoever, and they simply could not find anything to indicate any such struggle existed. Based upon the fact that the police and the district attorney determined there was no evidence of self-defense, criminal charges now have been filed. The question then becomes, does one actually have to be attacked to feel as though they were in fear of death or serious bodily injury from the person? Probably not. But Ms. Benefield's problem here is she may have stated that she was attacked, and if there's no evidence of being attacked, that hurts. Ms. Benefield should have asked for an attorney. We've talked about this before. When the police interrogate someone and they are in custody, they have to advise them of the Miranda rights. And one of the things that they advise them of is that you have a right to remain silent, hint, hint, wink, wink, nudge, nudge, say no more, and that you have a right to an attorney. And if you can't afford one, they will get one for you. And any attorney worth their salt is going to say, shut your mouth. And if it was in fact self-defense, guess what? They'll learn about that at trial. Bottom line, the case is not going to go away just by saying it was self-defense. Ms. Benefield, word to the wise. It's always the defendant's own words that get them in the end. You should have kept your mouth shut. We'll give you the presumption of innocence, but you should have not said a word. Next on the docket, our dumb criminal contestant winner from last week. And I have never seen someone with such an overwhelming victory. What a margin. Gilbert Cordero, 23. No need for a recount on this particular case. It was not even close. Mr. Cordero was the man who was in a sex toy store and thought that he could sample the merchandise, which was the auto blow. That's right. And he took out his parts and began pleasuring himself in front of the store employee. And then when he was done pleasuring himself, he put it back up on the stand. So, Mr. Cordero, I know you would probably like the auto blow, which apparently seems to be available through the manufacturer website, along with other accessories that you need. But here today, all you get is our Crime Talk mug. Now, some may say it's not just that. I agree. It is a Crime Talk mug. And Mr. Cordero, you can do whatever you want with this mug. Just don't do it in public. Congratulations. Now, as we've said before, if you would like cool Crime Talk merchandise like a mug, look at that, hit the link below, take you right to Teespring, order yourself a mug, get it done now. Why, you may ask? Christmas is coming, all right? Guys aren't going to order this stuff for their spouses, their significant others. You're going to have to do it yourself. Buy it, wrap it, put it under the tree. Do it yourself. If you want something done, just do it yourself. Go hit the link below and get your Crime Talk gear. Now, our dumb criminal contestant of the day. Is Mr. Henry Caballero. He's 49, and apparently Mr. Caballero needs a little anger management because apparently he went to a restaurant by the name of Checkers. I've seen them around. I'm not sure they're actually here in Colorado anymore, but the bottom line is he was not satisfied with his sandwich. Why, you may ask? Because he learned that they had no more lettuce to put on their sandwiches. Apparently, for Mr. Caballero, that was it. Enough is enough. He began yelling and screaming at Checkers employees and cursing them and put them in fear for their safety. When the police were called, Mr. Caballero, who was in his car, refused to identify himself, prompting an officer to remove him from the vehicle. And since he was uncooperative, guess what? That's right. He was not only charged with the conduct in the restaurant, he was now charged with resisting an officer without violence. These are both misdemeanors, but now he is in jail. Mr. Caballero, really? Let it go, man. It's lettuce. Do most people even like lettuce on their burgers? I'm not a big lettuce burger fan, all right? But if they didn't have it and I wanted it, you just say, okay, or what else do? You leave and go somewhere else where you can get it. Or maybe bring your own lettuce if you love lettuce that much. But you don't yell and threaten people that work at a restaurant and put them in fear for their life because you didn't get your lettuce. Mr. Caballero, let it go. At least something's come from this. You've got a trip to jail. You were able to post a bond. You're probably going to have to get an attorney, have probation, take that anger management class, pay some fines, court costs, supervision fees. Sure would seem like it would be a heck of a lot easier just to let it go. Mr. Caballero, you are our dumb criminal contestant of the day. We'll see if you can pull it out just like Mr. Cordero. Well, maybe not just like him and be the dumb criminal contestant winner of this week. We'll let you know how the vote count tallies. Thanks for watching. Have a great day. We'll see you tomorrow on Crime Talk as well as Crime Talk Live, 6 p.m. Mountain Time on both YouTube and Facebook. Have a wonderful day.